Hi, I'm Palak Agarwal of Hidayatullah National Law University and currently a legal intern at LEXIS and Company. One of the fundamentals of thought is that a person can be made liable only if he has caused a harm. But in some situations, the person can be made liable even if he did not cause the harm intentionally or negligently. Person can be made liable even if there is no fault of him. That is also known as no fault liability. Absolute liability is no fault liability because if there was the fault of the defendant, it would be treated under negligence. The rule of strict liability finds its origin in the English case of Rayland versus Fletcher, 1868. In this case, the defendant constructed a reservoir on his land to provide water to his mill. He was not aware that there were some disused mine shafts next to the reservoir. The water one day burst through the reservoir and went into the mine shafts and flooded the plaintiff's coal mines next to the mine shaft. There was no negligence on the part of either the defendant or the independent contractors. As the defendant did not breach any duty, so the court laid down the principle of strict liability. The court laid down that if a person brings a potentially dangerous thing on his land, if the thing escapes and does damages, then such person should be held responsible even if he was not negligent. In this case, the huge reservoir was held to be a dangerous thing. For the application of the rule, three things are necessary. The first is that some dangerous thing should be brought to the land. It is important that the thing escaping is a dangerous thing, is it is likely to do mischief when it escapes. It includes sewage, explosives, electricity, etc. The next essential is that it should be of non-natural use. For the use of land to be not natural, it must be some other use and not merely the ordinary use of land or such a use which is profitable to a community. For example, a person loves to sit next to the fire near the winter season. It is a natural use of land, and if the fire escapes and burns other houses, then the principle of strict liability won't be valid as it is a natural use of land. Most essential ingredient is that the dangerous thing should escape and cause mischief to others. That is, it should escape the control of the defendant and should harm the plaintiff. The defendant has certain defenses available against strict liability. Those are plaintiff's own fault. If the plaintiff himself intrudes in the defendant's property, then he cannot claim for damages suffered by him. The other defense is act of God. These are circumstances which are out of the control of human beings and cannot be foreseeable by human beings. For example, if in the case of Rayland versus Fletcher, a tornado was there which had caused the damages to the reservoir, then the defendant won't be liable. The other defense is consent of the plaintiff. If the plaintiff has consented to the accumulation of dangerous thing on the land of the defendant, then afterwards he cannot claim for the damages caused by the dangerous thing. The other defense is act of third party. If the damages are caused by some unknown person who is neither the defendant's servant nor his agent, then the defendant won't be liable. The other defense is statutory authority. If the damage is caused by someone who is performing his legal duty, then the person won't be liable to the damages caused to the plaintiff.